I'm so excited. I finally got my letter from UC Davis. I've been waiting weeks for this letter. Let's see what it says. I've been rejected. What? I'll try again next year. You know what? We'll try again next year. I'm really nervous this time. I got my letter from the UC Davis again. I got rejected last year, but I think I'll get in this year. I know I've worked hard. I studied really hard for my MCATs. Let's see. Dear Mr. Bach, we regret to inform you that you've been rejected again. This is an outrage. I'm clearly qualified to go to this medical school. I'm going to have to talk to my lawyer.
The story behind the 1978 Regents of the University of California versus Bakke goes like this. Alan Bakke, a 35-year-old white man, had applied to the UC Davis Medical School once in 1973 and a second time in 1974. He was rejected both times, despite being more qualified in college GPA and test scores than all other minority applicants that were accepted at this time. The school's affirmative action program reserved 16 places in each entering class of 100 for qualified minorities. Bakke and his lawyer, Reynold Colvin, claimed that he is excluded from admission solely on the basis of his race. The case made its way from the California courts all the way to the Supreme Court, where the split decision was 5 votes for Bakke and 4 votes against. The Berger Court held that a rigid quota system violated the Equal Protection Clause under the 14th Amendment, but that race was still a legitimate consideration for hiring and admissions.
In the 2002 Supreme Court case Gratz v. Bollinger, the court, in a 6-3 opinion delivered by Chief Justice William Rehnquist, held that the University of Michigan's use of racial preferences in undergraduate admission violated both the Equal Protection Clause and Title VI. The Supreme Court ruled that public colleges and universities could not use a point system where every minority student automatically had an assigned value added to his application regardless of other qualities to increase minority enrollment, but could take race into account in vaguer, narrowly tailored ways to maintain academic diversity. In 2003, another Supreme Court case alleged that the University of Michigan was violating the Equal Protection Clause. However, in Grutter v. Bollinger, the court ruled 5-4 that the University of Michigan's law school did not violate the Constitution in its use of race in admissions, because all applications were still considered individually and holistically, so that no acceptance or rejection was based automatically on race, and that the program does not unduly harm non-minority applicants. From August 2011 to February 2012, the Department of Education's Office of Civil Rights was investigating Harvard and Princeton universities for claims of discrimination. The claims allege that these schools practice discrimination by holding Asian Americans to a higher standard than other applicants. The claim has since been dropped, and the school's response to this was that they use a holistic view of a student, and scores like SAT and GPA, which clearly show a disparity between different races, cannot be used to prove that the races showing lower scores are less qualified. Decided less than a month ago in November 2012, the Supreme Court ruled on another case regarding the University of Michigan's affirmative action policies. The Coalition to Defend Affirmative Action sued the University of Michigan because of Proposition 2, which had been voted into the state constitution and banned affirmative action in government hiring, government contracting, and admission to public universities. They claimed that it violated the 14th Amendment's guarantee of equal protection, and the Supreme Court agreed. The ban, the court said, unfairly placed a special burden on supporters of race-conscious admissions policies. 7 states besides Michigan, Arizona, California, Florida, Oklahoma, Nebraska, New Hampshire, and Washington, still forbid the consideration of race in public university admissions. Fisher v. University of Texas is an ongoing Supreme Court case. Abigail Fisher is suing the University of Texas for violating the Equal Protection Clause through its consideration of race in admissions. If the plaintiff's charges are upheld, the Grutter v. Bollinger decision would be overturned, and a historical mandate against race-conscious admissions would be put forth. The other possible outcomes of this case are a tightening of current limitations on the consideration of race or ethnicity to a similar effect as the Gratz v. Bollinger decision, or maintaining the status quo by rejecting Fisher's claim. To us, one of the most compelling arguments is, by and large, the beneficiaries of affirmative action are not the poor inner-city children who are actually disadvantaged, but rather suburban middle to upper-class minorities students. Tell me honestly, what great adversity is facing a middle-class black suburbanite versus a middle-class white or Asian suburbanite? Lastly, though affirmative action was necessary immediately after the civil rights movement to overcome legitimate disadvantages, the playing field has since been leveled, and the continuation of this program prevents achieving a truly colorblind, racially equal society, because it disincentivizes high achievement for selected minorities. If you knew you only had to get a 1900 on the SATs to get into your dream school, would you really study to get a 2300? Very few would. Thus, true minority achievement is disincentivized and discouraged. Words of Brother Martin Luther King, Jr. I have a dream that my 4 children will one day live in a nation where they will be judged not by the color of their skin, but by the content of their character. I share this dream. All I want is to be judged by the content of my character, by my merits and qualifications as another person. Whether my name is Chang, Dyer, Williams, Smith, Patel, or Rodriguez, I am still the same person. This is why we need race-blind admissions. 2 wrongs don't make it right. Politically correct discrimination is no better than politically incorrect discrimination. It's still discrimination, and it's still wrong.
Affirmative action is incredibly influential on the distribution of society. In education and the jobs market, affirmative action deeply affects the demographics that are accepted or hired. Colleges are more inclined to accept or reject someone on the basis of their race. Asian Americans, and to a lesser extent Caucasians, have much higher standardized scores and GPAs, while their African American, Hispanic, and Native American counterparts are admitted to the same universities at a much lower standard. This does mean that there are more minority professionals, doctors, lawyers, teachers, and executives than there would be without affirmative action, but it also means that in many cases, people who are more qualified are kept out of these positions. The decision will frequently be revisited until it is overturned, which it inevitably will be. It is just a matter of when. In the Grutter versus Bollinger decision, Justice O'Connor was noted for saying that in 25 years or sooner, affirmative action would no longer be necessary and would be unconstitutional. Affirmative action will still be controversial even if it is overturned. Groups like the NAACP that have a vested interest in affirmative action will protest hard against its removal. It remains to see how the Fisher case will be decided, though we do not believe that the court will overturn affirmative action yet.